Theo Key, the legendary political scientist from Harvard who grew up in Lubbock, Texas, observed once that Northerners, provincials that they are, regard the South as one large Mississippi. Southerners, with their eye for distinction, place Mississippi in a class by itself. Every Southern state finds some reason to fall back on the soul-satisfying exclamation, "Thank God for Mississippi." Yet Mississippi only manifests in accentuated form the darker political strains that run throughout the South. Now, Professor Key wrote those words in 1949 in his classic book, Southern Politics, which is the first great modern quantitative political science work, a work commissioned by the Rockefeller Foundation to try and understand the impact of voting devices and poll taxes on voter participation in the South. It is still assigned on university campuses today as a standard text in Southern politics courses and in courses on election law and voting rights, and in history classes on the South. It probably has the most durable shelf life of any political science work written since 1920. It's an amazing book. I recommend it to you all. Or come out of my Southern politics class and it will be assigned. But the problem that Key dealt with is the problem of voting rights. If you were to look at the South, if you were to look at a South in 1962, you would see a South where the state legislature would be dominated by Southern counties, most often because every county was guaranteed at least one representative in the state legislature. You would discover that there would be anywhere from a 20 to a 70-point voting registration disparity between white and black residents of the southern states, and in particular counties. You had numerous majority black counties where there were literally no African Americans registered to vote. None. Violence, intimidation, the use of literacy tests, poll taxes, voter purges, felon disfranchisement had spent 4 generations completely eradicating the black electorate in much of the South. If you were to look 4 years later, 1966, you would discover that every southern state would have a state legislature where legislative seats were of roughly equal population, where tremendous political power had moved to urban centers and to suburban counties. And you would also see a tremendous growth in African American and also a growth in white voter participation. In southern states, you would discover a majority of African Americans of voting age registered to vote. Voter turnout would take longer. In 4 years' time, we had this dramatic upheaval of how we drew legislative districts in the South and also of how we registered people to vote. It's probably the most tumultuous overturn of the electoral regime in the history of the United States. And it has endured for a half century, and the reason it did is because of the Voting Rights Act of 1965. Recently, the U.S. Supreme Court took up a challenge to a provision of this act, which I'll detail in a moment, in a case called Shelby County v. Holder. Shelby County is a prosperous suburban county south and east of Birmingham, Alabama. It is a prosperous, predominantly white, relatively affluent suburb of about 240,000 people, about 200,000 people. 50 years ago, it was a rural county with a few bedroom communities with about 25,000 residents. And like all of the state of Alabama, it had been picked up under a provision of the Voting Rights Act called Section 4 of the Act, which is often referred to as the trigger. When a jurisdiction, a state or a county, is picked up by the trigger, it becomes subject to what was called Section 5 of the Act. Section 5 is the most powerful federal tool ever leveraged against a state. What Section 5 would do is it would freeze in place all election laws in a state or a county. And the only way a state or a county could change that law would be by having either the federal district court in the District of Columbia or the U.S. Department of Justice approve their change in the law, while providing that the county or the state proved that the change in law was non-discriminatory, that it would not make minority voters worse off than they were before the change. Okay? Now, One thing we know is that the Constitution anticipated that voter qualification would be determined by the states. That amending the Constitution over time had put into place constraints under which the states could deny the franchise. And under the 14th Amendment, equal protection under the law, and under the 15th Amendment, the right to vote, could not be taken away on the basis of race, creed, color, or national origin. Nonetheless, systematically, from roughly 1890 until 1964, Southern states had systematically removed black voters from the rolls, denied them access to the ballot, denied them the ability to influence elections through both legal and extra-legal means. The government had tried to deal with this using a variety of mechanisms in the 1950s. They had amended the law to allow the Department of Justice to seize voting records, to bring lawsuits on behalf of plaintiffs, and to go into court and try and challenge discriminatory practices. But the problem is they would go into a court in a state where a Southern judge had been appointed by the president, subject to the advice and consent of the Senate, nominated with the endorsement of the state senator, who is going to be a conservative rural Democrat, more than likely. Department of Justice was not having a lot of success in local jurisdictions in the South winning voting rights cases, in part because there was not good law to guide the litigation. The Voting Rights Act of 1965 was designed to do this thing. Advanced by Lyndon Johnson after the March on Selma Bridge and the Sunday Massacre, which resulted in the death of a number of white and black protesters demanding equal voting rights. By the end of the summer of 1965, the act was put into place. Most of the act is what we would call permanent law. But an important provision of the act, sections 4 and 5 that I had mentioned previously, have what are called sunset provisions put on them, which means that they exist in law only for a certain period of time, then the legislature must revisit them and renew them in order for them to continue in law. The permanent provisions of the act suspend and get rid of the use of tests and devices in elections. They allow Department of Justice to send registrars into jurisdictions with a history of voting discrimination to register people to vote. And they also allow Congress to use their 15th Amendment authority to pass a law to allow Department of Justice to sue a state if they're engaged in discriminatory electoral and voting practices. What has to happen is a person or the Department of Justice has to bring a lawsuit. They challenge the voting practices of a state or a community. And if the plaintiff, if the DOJ or the personal plaintiff can demonstrate a discriminatory effect that usually results in a minority preferred candidate losing or a diminution of equal access to the ballot for minority voters, they win. That's the simplest way of putting it, they win. If you cannot prove these effects, you lose. Demonstrating intent can be a component of this litigation, but intent is not necessary. All you have to show is a discriminatory effect, not a discriminatory intent. So we have a relatively low standard for overturning an election practice. Section 2 cases from 1982 to 2005, 336 of these were brought, roughly 1/3 were successful, 2/3 failed. The most successful ones are usually redistricting cases where redistricting practices have made it difficult for minorities to get equal access to representation, either on a county commission or in a state legislature. These provisions of law are still in place. They have not changed. And these are the tools that have affected the most change in voting rights throughout the United States. This law applies nationwide. Section 4 and 5 of the Act, which I mentioned previously, the emergency provisions, apply only to certain parts of the country. Under Section 4, what's called the trigger coverage, what has to happen is you have to have a history of the use of a test or device in registering people to vote. And in the 1972 presidential election, based upon the latest iteration of the law, you needed to have less than half of the eligible electorate either register to vote or show up to vote. So if you have low voter turnout and you've used a test or device, you trip the trigger, your election laws are frozen in place, and any change in law either has to go to the District Court in the District of Columbia, which at the time in 1964 was the most progressive federal court in the United States. Or you go to the Department of Justice for what's called administrative review. Now, this provisional law has always been controversial, in part because it fell heavily on the South, and actually until a few weeks ago, it fell only on certain states. The original law covered all of Alabama, Louisiana, Mississippi, Georgia, South Carolina, Virginia, and half of North Carolina. It was supposed to last for 5 years. The act was renewed in 1970 for 5 more years, and then in 1975 it was renewed again. They added a condition to the test and device provision to also include a state law mandating English-only ballots. Combining voter turnout in 1972, low turnout in 72, with the use of English-only ballots, you picked up all of Texas, all of Arizona, all of Alaska, 3 boroughs of New York City, Manhattan, Brooklyn, and the Bronx, 2 counties in South Dakota, 4 counties in California, 2 townships in Michigan, 4 counties in Florida, and 9 townships in New Hampshire, all of which are over 90% white, one of which has no one living in it. Okay? So I don't know how you measure anything up there, but. And this was the law, and it was renewed for 7 years. In 1982, the act was revisited again. The trigger, the coverage formula, was renewed for a period of 25 years, using data from 1972. Then in 2005 and 6, Congress held hearings again and renewed the law for another 25 years, covering the same parts of all or some 16 states that got picked up in 1975, using electoral data from 1972 to determine if you should be covered. Now, this coverage formula is what was challenged in litigation by Shelby County, Alabama. What Shelby County did is they challenged the coverage formula, arguing that essentially times had changed. If you looked at the southern states, the discrepancy, voter turnout in southern states was as high or higher than most states in the Union. Southern states had the lowest discrepancy in black and white voter turnout. Indeed, in many southern states, black voters are more likely to vote than white voters if they're registered to vote, and more likely to register to vote if they're eligible. The renewal of the act, according to the plaintiffs, had not considered current circumstances and didn't use a coverage formula that reflected current circumstances. They were relying on electoral data from 2 generations past. Challenge goes to the district court. They fail. It's appealed to the appellate court. They fail. They come to the U.S. Supreme Court. The U.S. Supreme Court here takes up the case, having already sent a warning shot to Congress that there might be a problem with the Voting Rights Act. What's that problem? Well, 5 years ago, a case was brought out of Texas called Namudno v. Holder. North Austin Municipal Utility District Number 1 v. Holder, Namudno. And what that case did is it covered the ability of a jurisdiction to petition to quit being covered by the Voting Rights Act by the emergency provisions. That lawsuit actually succeeded, and the MUD in Austin was able to get out from being covered by the Voting Rights Act. They regained control of their elections. But in that decision, Justice Roberts, writing for an 8-1 majority, there was no dissent defending the Voting Rights Act, argued that there was reasons for concern with the coverage formula, the use of old data, the lack of acknowledgement by Congress in terms of the change in the South, that made the act potentially vulnerable. And it basically implored Congress to go back, revisit the Voting Rights Act, and fix the coverage formula. Now, Congress had been warned about this during the renewal hearings. Several scholars walked into Senate and House hearings and told Congress they had this problem with their coverage formula. Shelby County case comes down, and what happens is the court, by a 5-4 vote with the Gang of 4 conservatives plus Justice Kennedy, voting to strike down the coverage formula under Section 4 of the Act. Argument made by the court was that the data used by the federal government to decide if a state needed to have their election laws suspended in place was too old. It didn't reflect contemporary problems with voter participation. Now, in South Carolina v. Katzenbach 45 years earlier, Justice Warren had noted in defending the constitutionality of the coverage trigger under the 15th Amendment that the coverage formula was a usable proxy to reflect where problems existed. That if you look where the problems were, the coverage formula was a useful proxy. So the court is coming back 45 years later saying, this is not a usable proxy. It no longer reflects where the problems are. Strike down the provision. So instantly, 16 states or portions of states around the U.S., including Texas, all are part of non-southern states, are no longer bound by federal authority in changing their election laws. And they don't lose any time. In North Carolina, they changed their voter ID law. Texas runs through their new voter ID law. Texas is revisiting redistricting that was being litigated over issues related to Section 5 of the Act. And the media and the pundits go indiscriminately crazy, declaring that the heart has been ripped out of the Voting Rights Act, that the act has been completely devastated, losing its effectiveness. And it's true, the most powerful tool the Department of Justice had, the ability to deny to a state the ability to change their law, had been wrested from their hands temporarily. Section 5 of the act that gives them the authority is still constitutional, but they don't have a good coverage formula. So standing in the summer of 2013, Congress confronted a situation where they needed to figure out how to restore this law. There are Republicans such as James Sensenbrenner, chairman of the Senate Judiciary Committee, who wants to restore this law. There are Democrats who want to restore this law. Could they do it? Well, entering that debate, it was challenging, very challenging. And at the time of this discussion, we don't know the answer. Fact is that it will be very difficult to restore the old voting rights regime. The first thing is that the political dynamic in Congress is such that there may not be a stable majority available to pass a new working coverage formula. Why? Well, the conservatives in the Senate are numerous enough in opposition to this, coming mainly from states covered by the old law, that they will likely threaten filibuster to prevent a new bill from being passed. Second problem is the House has changed. It was a Republican Congress and President Bush that renewed the act and renewed the provision of the act that was declared unconstitutional. It was also Republicans out of this same Congress who facilitated creating the documentary record that was used to challenge the act. Now, most all of them voted for the act and facilitated the introduction of information that was used by the court to overturn the act. But even since then, Congress has become much more conservative in the House. The Republican House caucus is much more dominated by 10th Amendment thinkers, by reactionary politicians, people who engage in originalist thinking. And they're not inclined to pass legislation that gives the federal government veto authority over what is deemed to be a right of the state to conduct elections. Second problem is Congress has no idea what they're trying to do in terms of determining what to regulate. They don't have an evidentiary basis to ascertain areas that have real voting rights problems. Many of the voting rights problems in the United States exist in the South, but many of them also exist beyond the South in places like Indian country. If we were to look at for discrepancies in voter participation in the United States in the 2012 election, we would discover that the difference between white and non-white voting rates and registration rates are lowest in the old Confederacy. They are highest in the Plain States and the Mountain West. To a lesser extent on the Pacific Coast, Michigan, Upper Midwest. The biggest disparities in white versus Hispanic voter registration rates, citizen rates, we're talking citizen data here, among citizens, are in Alabama and Wisconsin, which is not a place we think of as usually having a voting rights issue. So Congress has to figure out the problem they want to fix. Instead of trying to fix the problem for the past, they're going to have to enter into a real investigation and debate over what the modern problem is, then devise a coverage formula to pick up those places. This creates a second problem, which is lawmakers who have voted for this act in the past represented states that would never be covered by it. Now they're threatened to be covered by it. And that means we may find some lawmakers from unusual places discovering a states' rights perspective. And it'll be very interesting to watch that be reconciled. Now there is a solution though. There is a solution to this. Department of Justice wants to be able to address places where we have the greatest discriminatory problems. And they've determined, to be honest, quite successfully and effectively that Texas is one of the problems. Okay? Texas has a generally bad record on voting rights, in voting rights litigation, and they have problems with both effect and intent. So what Department of Justice did almost immediately after the decision came down in the Shelby County case in the summer of 2013 is they filed a suit challenging Texas's voter identification laws, and they've got litigation filed challenging Texas's legislative redistricting. They're doing this under Sections 2 and 3 of the Voting Rights Act. So using the permanent part of the law. But they're also making use of a little-known provision of the act that's permanent. It's called the pocket trigger, okay? And what the pocket trigger does is it allows that if Department of Justice brings a lawsuit against a state or a county over voting practices, and they win the lawsuit, and they demonstrate not only discriminatory effect, but also discriminatory intent, they can request the court place that jurisdiction back under Section 5 coverage. They can freeze that state or county's laws in place and require that state or county to come to DOJ to get any election law change approved. Okay? Now, DOJ has only done this 7 times ever, and the only state they ever did this in comprehensively was New Mexico for a period of about 10 years. So they're making this choice in Texas. The problem is Section 3 and Section 2 cases are expensive. To give you an example, I believe that the 2003 Texas redistricting trial, the Tom DeLay remap, I want to say the total litigation bill for all parties involved was somewhere in the neighborhood of $12 million. Okay? Lawyers are expensive. Lawyers are expensive. Experts are expensive. It is an expensive proposition. DOJ is going to have to get into the practice of one at a time in it, for lack of a better way to put it. Having to take on each state and affirmatively proving the state has a problem. Under the old regime, when Section 4 existed and Section 5 could be applied, we presumed the states would act with bad intent. Ross Barnett observed. Legislatures can change laws faster than courts can overturn them. We assume they will act in bad faith. We freeze their laws in place. They come to us and ask for permission to change. That's the old regime. The new regime is we have to show they have bad intent. Then we get to freeze their law in place. This is a significant challenge for Department of Justice. Now there's a larger question, though, of whether or not the court did the right thing. Now, of course, here's the peculiar thing about right that we all know. Right is a political term. It's a value judgment, right? They followed the law. They followed the law. They made a decision that is politically unpopular. They've been doing that a lot the last few years. They made a decision consistent with the Constitution. They asked Congress to demonstrate the why of the need to upset the traditional state-federal relationship in the conduct of elections. And Congress, in the opinion of the court, came up lacking. They gave Congress the opportunity to fix this in advance of striking the law down. Will it be fixed? I don't know. The political environment is such that it is likely going to be very difficult in the years immediately following the Shelby County decision to put together a congressional majority in both chambers that will pass a law that will meet constitutional muster in the eyes of the High Court. Should the Democrats win complete control of Congress eventually, doubtlessly they will revisit this issue with a Democratic president. But until then, Department of Justice seems to be in a position where they have to take the hard slog of affirmatively proving where the problems are instead of simply presuming where the problem is and asking the states to fix them. Thank you very much.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.